Chairman Fowler, Ranking Member Brennan, and members of the House Education Committee, thank you for this opportunity to provide opponent testimony on House Bill 486. My name is Gary Daniels. I am here today representing the ACLU of Ohio. As this committee knows, HB 486 is an uncomplicated bill essentially confirming Ohio's K-12 public school teachers and faculty at our state universities and colleges are permitted to teach about religion in their classrooms. If that is all HB 486 seeks to accomplish, then House Bill 486 is entirely unnecessary, and its introduction is deeply puzzling. The First Amendment to the U.S. Constitution, as well as the Ohio Constitution, already allows for such instruction and discussion in our classes and coursework. Of course, there are wise and necessary parameters under the First Amendment regarding this subject. In short, the Establishment Clause mandates the government remain neutral with regard to religion. Government can neither advance nor inhibit religion. So, for example, an 8th grade history teacher can say some Europeans who arrived centuries ago on our shores were motivated in part by religious freedom they hoped would be more fully realized than from where they departed. Using another example, it is okay and historically accurate to say many of those motivated to end slavery in the U.S. were motivated by their religious beliefs. And if teachers and faculty are confused about where some of those lines are drawn, plenty of resources exist to assist them and have been available quite literally for many decades. But Ohio has hundreds and hundreds of public schools and universities and thousands of faculty teaching students. So it is understandable sometimes there may be an unintentional hiccup with faculty crossing that line into impermissible classroom instruction or wondering how best to navigate these waters. If that is an issue, as was expressed during sponsor testimony, then we suggest working with such entities and stakeholders as school districts, superintendents, teachers unions, the Ohio School Boards Association, college and university trustees, and others to increase educational efforts for those tasked with educating our students so any such confusion is minimized. However, HB 46 does not stop there. Indeed, the other admitted goal of HB 46 is to promote Christianity to captive K-12 school students and also adults in our colleges and universities under the guise of, quote, reducing ignorance of American history, hate, and violence within our society, end quote. HB 46 then offers 24 examples of what sponsors believe are appropriate topics, such as the relationship of the Ten Commandments to the United States legal system, the religious backgrounds of the signers of the Declaration of Independence, role of the Mayflower Compact, and much, much more. All this is obviously designed to paint Christianity in the most positive light while deliberately avoiding the negative. Indeed, not mentioned among these suggestions found in HB 46 are such things as biblical and Christian religious justifications that were and are repeatedly offered for enslaving others, denying racial minorities and gays and lesbians full participation in society, denying women and others the right to vote, the displacement and slaughter of those already living on this land when Europeans arrived, and the invasions and takeover of foreign lands and countries via manifest destiny and other religious rationales. Also ignored are the numerous battles between Christian denominations that raged in the earlier days of this nation regarding who was a quote-unquote true Christian and the various policies and laws that regulated, restricted, and banned various aspects of those members of Christian denominations and other faiths who were disfavored and discriminated against via local and state laws. That is, laws governing who could live in a particular city or state or hold elected office, direct funding of government funding of specific Christian denominations, and much more. This is not a suggestion to incorporate these other viewpoints into House Bill 486. Instead, it is a warning what happens when government schools open this door to promotion and celebration of one particular religious faith or set of religious beliefs. If one of HB 486's goals is to truly clarify where these constitutional lines are drawn, it appears this bill will create far more problems than it solves. Along these same lines, constitutional concerns are not reduced or solved by adding additional denominations, religions, or religious beliefs to this mix. That would surely compound these problems in various situations. This all begs the question of why do this at all? Do we really want our teachers and instructors wading through this minefield, promoting one specific version of Christianity or faith while minimizing or ignoring all others, whether deliberately or inadvertently? Do we want faculty converted into pastors, essentially telling kids around Ohio their own beliefs, if any, take an official, government-approved backseat to Christianity? Is this what will foster a reduction of ignorance and hate and violence in our society? I see I'm running short here, so I'll just say 486 is at a minimum unneeded. Politicians leaning on schools and universities to teach their version of Christianity and religion is an idea rejected centuries ago, and for good reason. For these reasons and more, the ACLU of Ohio encourages this committee's rejection of House Bill 486. Thank you, Madam Chair.
Thank you for trying to respect the time limit, Mr. Daniels. We appreciate that. We have several questions from the committee. Representative Miller.
Thank you, Chair. Good to see you, Mr. Daniels. Just on a side note, isn't precedent whenever hearing a case or an issue or a bill or anything, you would start off with, here's why we need to make the change, here's why we need to convict this person, here's why we need to do this, and then the defense gets to say, here's why we shouldn't, and this why this is a bad prosecution or a bad bill or whatever. Is this normal to put the opponents up first in any?
Point of order, Representative,
I'm just
please.
curious if that's a precedent he believes in history is set.
Are you referring to the bill or to the gentleman's testimony?
Yes, I'm referring to his testimony as an opponent at the beginning of the process of hearing this bill. Is this normal? I'm just asking him if in this committee on this bill, is this the current precedent that he's used to? That was my question.
Thank you. You may proceed.
Through the chair to Representative Miller, I've been doing this for a while. I've seen a whole mix of lineups with regard to testimony. I think, as you know, of course, it usually goes sponsor, proponent, opponent, but not always. I've seen bills be introduced and passed out of committee with one hearing and only one hearing. I've seen bills get like 12 hearings and not pass out of committee. I will say, thankful to have the opportunity to come in and weigh on House Bill 486.
Very good. If I may. With that being said,
You may have your 1-minute follow-up.
yeah, thank you. With that being said, if we are to teach these specific Christian pieces of literature, history, what have you, does this create a litmus effect or a litmus test, effect in the classroom where, because if we teach, we assess, or in Ohio, we test and punish, and if we teach, we assess, would we not be creating a litmus test for this specific Christian history?
Mm-hmm. Through the chair to Representative Miller, I think what you're getting at is a concern that the ACLU of Ohio shares that the bill again can be read very basically. You're allowed to teach these things in class, which of course I think is widely understood among teachers and faculty and other stakeholders in this regard. But it does contain those other, I guess we'll call them suggestions as to what could be or should be taught. It's not a mandate in the bill, which of course is a good thing, but it does provide insight into, I think, that what the sponsors mean with this. There's always a concern, I suppose, when the body that essentially governs schools, not at the school board level, of course, or anything like that, but does have a hand in funding and setting curriculum and that variety of things, they wonder if this sends a message. We've seen this with all kinds of legislation on all kinds of issues. It's sort of the fix this or we will fix it for you kind of thing. And so the concern here is while we don't make it explicit in the bill or make it a mandate, this is exactly what we're talking about. And if this is exactly what we're talking about, this couple dozen examples, then it opens the door to a wide range of problems.
Thank you. Representative Click is recognized for a question.
Thank you, Madam Chair, and thank you, Mr. Daniels, for being here. I always enjoy engaging with you. Mm-hmm. And sometimes, once on 206, we were able to work together on some things. And I'll be honest, when I first began reading your testimony, I'm thinking, I like this, because there's some points that you make that are valid, which is it's uncomplicated, it's not a mandate, and this is already allowed. But I think you mix some things up in here. First of all, you say teaching religion. This is not about teaching religion, it's about teaching history, teaching accurate history that takes place. And then you say that we're avoiding the negative. First of all, we're not avoiding the negative. The negative is, number one, it's already out there. And you talked about discrimination against certain religions. Well, who was just doing the discriminating? It was the state that was doing the discriminating. And when you go back in history, and this is something I talk about frequently because it was my spiritual ancestors that were being discriminated against. If you look back in the history of the Anabaptists and the Baptists, They were putting us in jail. It was Patrick Henry that came and defended the Anabaptists for preaching. They were put in jail for preaching the gospel. And so I think the positive aspects are not where the
Representative.
government took over and mandated things, but it's where those independent groups rose up and said, no, this is not going to be so. And so
Representative, could you get to your question?
Yes, ma'am. I'm sorry. My apologies. My question is when we start teaching about the history of John Leland and Roger Williams, who were the dissenters, and we teach that in a positive light and say this is a representation of Christians, not what the state was doing, and the Freedom from Religion Foundation or some other group that is anti-Christian comes in and sues, are you going to defend the teacher who teaches that, because you said this is already legal, or are you going to be on the side of them when they sue the teacher for teaching these positive aspects of Christianity?
Through the chair to Representative Click, it all goes back to that fundamental concept and mandate within the Establishment Clause of the First Amendment that government is supposed to remain neutral in this regard. Those 24 suggestions are all about positive aspects of Christianity and some wider, religion, but mostly Christianity. And it talks about, it's, what is framed as historical truths. I mean, I think, when you talk about such things as, the 10 Commandments and the U.S. legal system, you're talking about 2 of those commandments, maybe 2.5 of those commandments, but all the rest, it's entirely religious in nature with regard to the 10 Commandments. And so when there seems to be a piling on of, this is what's positive about Christianity, we think that it upsets that neutrality, that sometimes fine line that schools and faculty and what have you have to keep in mind, saying that, look, in the name of reducing hate and violence and everything else, as it says in the bill, here's what we think are the fundamental parts of Christianity. Again, it upsets that balance, and it presents one side of Christianity. I'm not here to defend everybody or anybody's interpretation of Christianity, but this seems to be framing it as, this is what Christianity is. There are other Christians, of course, that would disagree about what Christianity means and what it requires of them, the faith does, that are not reflected in these examples, even though they are not mandatory. It does, I think, provide plenty of legislative intent as to what this bill is trying to do.
Follow up?
Representative, you had 30 seconds left for your follow-up.
Wow, that's pretty good. Thank you. So you mentioned the 10 Commandments, and are you aware of how many times the 10 Commandments appear in the Supreme Court of the United States, showing that was foundational to our law? Besides, there is an image right behind the Supreme Court justices. I've been there, and it shows Moses and the 10 Commandments right next to him. Are you aware of that foundation, and is it wrong to teach students that foundation about the 10 Commandments? And once again, you didn't answer my question. With all due respect, are you going to defend the teacher, or are you going to be suing the teacher who teaches these historical facts about American history?
Through the chair to Representative Click, I'm unaware, at least in ACLU of Ohio experience, when we have become involved in these types of things, suing an individual teacher. You typically sue the school district in that regard. So hopefully, that won't be a problem with the individual school teachers. And I will say, for those who are wondering, we don't jump to sue schools right away. Having been on the legal staff previously, I can't think of an example where we didn't first contact the school or the school district or the school district's council and say, hey, we've got a concern about this, and not rushing literally into federal court and making a federal court case about it. So there are parameters out there, including the one that you're mentioning about the 10 Commandments presence in the Supreme Court. So there are parameters out there, but this seems to really pile on the examples that are in here. Again, we're using the words of 486 itself, that this is meant to cast Christianity in a positive light. And if you're not including the negative, and again, that's not a suggestion to do it by any means whatsoever, then it's the government taking sides. And that's what the First Amendment prohibits. And I think it's worth mentioning, too, whether this violates Senate Bill 1 as applied to colleges and universities and controversial topics and subjects.
Final
Thank you
follow-up?
very much. We're going to move on, and if we have time, we'll come back.
Okay.
Ranking Member Brennan for a question.
Thank you, Madam Chair. Thank you for coming in. So I've thought a lot about this bill, because as I've said before, you know, I taught many of these documents in my classes over the years, and I agree with you that you can do a lot of this stuff already. But one of the things that occurred to me is, you know, as a Catholic, I believe that the Catholic Church is the one true Christian church founded by Jesus. So would this bill, if I were inclined, give me cover if I wanted to use examples from American history in my classroom, in my history class, maybe using examples of Christopher Columbus, the history of Maryland, Charles Carroll of Carrollton, who signed the Declaration of Independence, focusing on JFK and his writings, the Catholic charities and the social justice work that the Catholic Church has done throughout our nation up until the present day. Would this bill give me cover to teach my class in that biased fashion? Thank you, Madam Chair.
Through the chair to Ranking Member Brennan, you know, it would be, it's no pun intended. The devil is in the details, kind of thing. You know, does your subject, does your coursework on that particular day only involve Roman Catholics or Catholics and their contributions to society? If so, we're running into that mandated neutrality problem. And again, it doesn't solve the problem to talk about decades ago, centuries ago, how much discrimination Catholics faced at the hand of people of other Christian denominations, that inability to hold office, that funding of specific denominations that were not Roman Catholicism. Again, that you're only compounding the problem, you know, as you add on to it. And I don't see where schools and teachers and everyone are clamoring for something like House Bill 486 is necessary, when again, the resources to navigate these waters have been out there for many, many decades, including with ACLU on the national level participation.
Madam Chair, quick follow-up.
Continue.
Thank you. So I agree. That's a good point, and that was the point I made last week, is that I was a social studies teacher for 30 years. And I've come across hundreds of social studies teachers, never had anyone express this concern to me. I gave my personal cell phone number on the public record last week. If you missed the committee and you're watching, go back and listen to it. Please call me and let me know if this is a problem for you in your classroom. I will not divulge your name. I promise I would not do that to anybody. But my question is, does this set a new precedent when it comes to schooling in the state of Ohio?
Through the chair to Ranking Member Brennan, it depends, I guess, on how exactly you want to read the bill. You know, is it absolutely unnecessary because it repeats what is already the status quo in Ohio? In that sense, it doesn't. But when you peel back the layers, which isn't too hard to do given the text found in the very bill itself, I think it's clear what is going on here is positive promotion of Christianity, which is fine. We have a First Amendment, to do that. We can do it in a wide variety of settings, and we do it every day, all the time in the United States and Ohio. It's different when you're doing it in a school environment, though, when you're talking about government schools that are bound by the First Amendment.
Thank you. Thanks, Madam Chair.
Thank you. Representative Newman is recognized for a question.
Thank you to the chair, and thank you to the witness for your testimony today. I have a question for you from your testimony, paragraph number 4, where you refer to the First Amendment regarding its and the Establishment Clause mandates that the government remain neutral with regard to religion. Government can neither advance nor inhibit religion. I noticed those words are not in quotes, but I was curious if you drew those words in that definition, your definition of the Establishment Clause. I wonder if you drew that definition from the words of anything in the Constitution or the Declaration of Independence or any words of our founding fathers, seeing that, because in the early days, the Bible itself was actually used as textbook in our schools. So I'm just wondering where you drew your definition of the Establishment Clause.
Congress shall make no law respecting the establishment of religion nor preventing the free exercise thereof. That's neutrality. right there. And that has been backed up by decades worth of court cases from, trial courts on up to the United States Supreme Court about exactly how to handle these issues inside schools and outside schools. With regard to the Founding Fathers and things of that nature, I'm not here to say that the Founding Fathers were an ideological monolith that thought the same thing about everything. That is absolutely not true. There was all kinds of differences of opinion, and there was a fair amount, quite frankly, of hypocrisy. We had, these great, wonderful documents that talked about the equality of man and equality of people while we enslaved others. So we did have plenty of politicians back in those days who said one thing and then did quite another. So I think there is certainly some use and utility in listening to what the Founding Fathers had to say about a variety of different things, but sometimes their actions don't reflect their words.
You may follow up.
If I could have a follow-up, please. Yes, thank you to the chair. So the words of the Founding Fathers, which weren't exactly this quote of their definition of the Establishment Clause, but in their mind, this version of the Establishment Clause did not prevent, in their thoughts, it being right for the Bible to be used, actually, as a textbook in the classroom. Would you agree with that? Mm-hmm.
Through the chair to Representative Newman, I would just go back to what the Founding Fathers, and again, the Founding Fathers, there's not like a capital F Founding Fathers, that there's this one central repository of exactly what they all thought. There were differing opinions, including exactly over the First Amendment. The First Amendment that we have right now, and the Establishment Clause of the First Amendment, was not the first draft by any means, because they had debates over, should this simply prevent a national church or national religious body, and they rejected that. And they said, no, we're not talking about a religion, we're talking about religion. And so, you can use speech as an example as well. They passed wonderful words of the First Amendment about being able to speak your mind and engage in free speech, and then they, not too terribly long after, passed the Alien and Sedition Acts. Quite a violation of the First Amendment there. So, it's again, I think we can rely on, these Founding Fathers and framers for some things, but let's not pretend, that they were just, ideologically consistent across everything and they all thought the same thing about every issue that was before them.
You have 30 seconds remaining.
30 seconds to get my button on here. Thank you to the chair and for that, for your answer. So I appreciate your clarification there in the answer you just gave, that there's a distinction between establishing a particular church as the state church, as a national church, in distinction against a different idea, which is establishment of or freedom of religion and freedom of speech. So those are different ideas, establishing a particular church versus freedom of religion and freedom of speech. So I appreciate you making that distinction, and I think that's pertinent to the definition of the Establishment Clause. Thank you.
Do we have any further questions from the committee? Representative Click.
Thank you, Chair, and again, thank you for your patience and your toleration and your endurance for standing up there, taking our questions. I just want to go back to this. Are you aware, I don't know if you're aware or not, but ACLU can be kind of intimidating. And so you talk about writing letters rather than lawsuits. And I think that silences the speech that some people might want to have. And again, you've said a couple times, teaching religion. We're not teaching religion. We don't want people to teach religion. We want people to teach history. But some teachers are afraid to teach the positive impacts. And that's why we say the positive, because that's where people fear. There's no lack of teaching the negative impacts of religion on society. That happens all the time. But people are afraid to teach, for instance, that the First Amendment was actually a byproduct of Christian teaching. It came from Roger Williams, who was a preacher and a pastor and a politician who was run out of Massachusetts. And it came from folks like Pastor John Leland, who fought for it and debated with James Madison to ensure that in the Bill of Rights. And it was signed by a pastor, Frederick Augustus Muhlenberg, who was the Speaker of the House. So my question goes back again. So if the Freedom from Religion Foundation sends an intimidating letter, are you going to
Representative.
send an intimidating letter if they teach that positive aspect of Christianity? Or if someone else sends an intimidating letter, are you going to come to their defense? Or are you
Representative.
going to be attacking them for teaching that positive aspect of Christianity?
Through the chair to Representative Click, I won't use the sort of pun about the devil in the details, but, I will use that, common legal refrain to these types of things, that the answer to any legal question is it depends. If a teacher wants to talk about that there were religious motivations behind certain foundational principles and documents in the United States history, I don't think anybody really sees a problem with that. I think schools have been doing that for a number of years and decades and continue to do that now. But the examples that are in the bill there, anticipate that, again, that this is all positive, 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 positive. And that's okay if people have, quite acceptable and understandable and is their right, if people frame and think of their religion in an entirely positive light. But again, it begs that question of if all you're doing is saying the positive and framing that as historically accurate, does that cross the line? And that's our concern. So if there's, just sort of a foul tip, let's say, with regard to what a teacher is doing, what they're saying, and it generates a letter from the ACLU of Ohio or someone else, we get involved when there's, clearly some sort of just over-the-top behavior going on or where it seems systemic in nature. I can think of, for an example, a situation, I believe it was back in the 1990s, where in suburban Cleveland, in Lakewood, some teachers came back from a conference and started teaching biblical creationism in their high school classroom. That generated a pretty quick response from us. We didn't rush to court to sue. We sent a letter asking to clarify and saying if this is indeed what's going on, then you need to knock it off because it's unconstitutional, and indeed that's exactly what happened. So to the extent that anybody, again, is concerned about or puzzled as to where these lines are drawn exactly, the U.S. Department of Education has plenty of resources, teachers unions have plenty of resources out there. There's just a wide variety of people coming at this, all from the same angle, saying this is what's acceptable to teach in schools and not. And if there is some particular problem in Ohio, then we could work on additional educational efforts that I don't think rise to the level of having to have this bill or turned into law should it become law.
Ranking Member Brennan, recognized for a follow-up.
Thank you, Madam Chair. Thanks again for all that. It's a good debate. Do you think there are any amendments that could be made to this bill that would change your position from opponent to interested party? Thank you, Madam Chair.
Through the chair to Ranking Member Brennan, again, our concern isn't, I think what we would simply be saying is continuing to say is the bill is not necessary if all it does is say, hey, you know what, you can do this as teachers or instructors in our K through 12 schools or universities and colleges. But it's all of the other language that, granted, it won't make it into final law. When you read this bill as enacted, all those examples aren't going to be in there or anything. But I think, again, it does provide plenty of legislative intent as to what's going on here. So if that part were taken out, I think we would essentially be interested party if we would have any position whatsoever. If it just says, yeah, you can do this. Although, again, I think it is worth looking into as applying to colleges and universities whether this would be allowed under Senate Bill 1.
So, Madam Chair, very quick.
Yes.
Could you provide us with an amended version of the bill that you'd be amenable to?
Yeah, so we have a, yeah, it'd probably be the bill with a lot of lines blacked out, but that's what it would amount to because it's or I could provide the First Amendment. That's what we have.
Thank you, Madam Chair.
Seeing no further questions, thank you for your
Thank you.
testimony.